Good day. We begin with a significant legal development concerning U.S. citizenship policy. A federal judge in Massachusetts has decided to maintain a nationwide injunction, blocking President Donald Trump's executive order aimed at restricting birthright citizenship. In his opinion issued yesterday, U.S. District Judge Leo Sorokin argued that limiting the block to only the states that filed the lawsuit would be impractical and would create significant administrative and financial burdens. The judge stated, and I quote, "The record does not support a finding that any narrower option would feasibly and adequately protect the plaintiffs from the injuries they have shown they are likely to suffer." This ruling is particularly noteworthy as it comes nearly a month after the Supreme Court, in the case of Trump v. Casa, cautioned against the broad use of nationwide injunctions by lower courts, suggesting they often exceed the authority granted by Congress. However, Justice Amy Coney Barrett's majority opinion did leave the door open for such injunctions when they are necessary to provide complete relief to the plaintiffs. Judge Sorokin's decision leans heavily on that exception, concluding that the interconnected nature of state and federal systems for identification and benefits would make a patchwork of policies unworkable. The original executive order sought to challenge the long-standing interpretation of the 14th Amendment, which grants citizenship to nearly all individuals born on U.S. soil. The legal battle over this fundamental aspect of American law is expected to continue, with this latest ruling ensuring the policy remains on hold for the entire country for the time being. From a contentious legal battle to a closely watched regulatory one, the Food and Drug Administration is also in the spotlight. FDA Commissioner Marty Makary has stated he has no immediate plans to alter policies regarding the abortion pill Mifeprione. However, he stressed that the agency is conducting an ongoing and thorough review of the drug's safety data. In a recent interview, Makary said he has no preconceived plans to modify access to the pill, which is used to end a pregnancy within the first 10 weeks. But he was quick to add a significant caveat, noting that the agency must remain open-minded and will not hesitate to act if new data reveals a significant safety concern. This careful positioning comes amid sustained pressure from some Republican lawmakers. Senator Josh Hawley of Missouri, for example, recently sent a letter to the commissioner urging him to restore critical safeguards on the use of Mifeprione, citing what he described as new data on safety. The commissioner's comments echo those he made earlier this year, where he assured that he has no plans to take action, but could not promise inaction if a real signal of risk emerged from the data. This leaves the future of the drug's accessibility in a state of uncertainty as the FDA continues to balance its current policies against the ongoing review and political pressure. Meanwhile, on Capitol Hill, a new legislative effort is underway to reshape state-level firearm regulations. Republican Representatives Elise Stefanik of New York and Darrell Issa of California have reintroduced the Modern Firearms Safety Act. The bill is designed to prohibit states from imposing their own unique requirements on handgun manufacturers. Specifically, it would ban states from mandating that handguns incorporate specific design features, safety mechanisms, or performance standards that are not already required by federal law. The legislation takes direct aim at so-called handgun roster laws, most famously implemented in states like California and New York. These laws create a list, or roster, of handguns that are approved for sale, often requiring features like magazine disconnect mechanisms or micro-stamping technology. Proponents of the new federal bill argue that these state-level rosters stifle innovation, make it difficult for manufacturers to introduce new and improved models, and artificially inflate prices for consumers by limiting supply. Critics of the bill, however, maintain that these state laws are a crucial tool for ensuring that only firearms with modern safety features are available to the public, giving states the ability to enhance public safety beyond federal minimums. The reintroduction of this bill signals another front in the long-running national debate over gun control and the balance of power between federal and state governments. In the arena of high-level politics, President Donald Trump has weighed in on the recent Supreme Court ruling on presidential immunity, suggesting it likely offers protection to his predecessor, Barack Obama. Trump's comments were made in response to a question about recent disclosures from the Director of National Intelligence, Tulsi Gabbard. Earlier this month, Gabbard declassified documents that she claims show President Obama and his cabinet members manufactured and politicized intelligence to create the foundation for what she termed a years-long coup against President Trump. Former President Obama has issued a statement strongly denying these allegations. Gabbard has since stated that she referred several Obama-era officials to the Department of Justice and the FBI for potential criminal prosecution based on the declassified information. It is within this charged context that Trump made his remarks. He connected the situation to the Supreme Court's landmark decision, which granted presidents absolute immunity for their official acts while in office, but not for private conduct. Trump suggested that the actions alleged by DNI Gabbard would likely fall under the category of official acts, and therefore President Obama would be shielded from prosecution under the court's new precedent. This assertion intertwines a major political controversy with a fundamental question of executive power, adding another complex layer to the ongoing fallout from the intelligence disclosures. Turning now to international security, the U.S. military and its allies are making a major show of force in the Indo-Pacific. In a milestone for regional defense, the U.S. Army and the Australian Defence Force have conducted the first ever live-fire test of the new Precision Strike Missile, or PRSM, west of the International Dateline. The test, which took place in Australia's Northern Territory, saw the advanced missile launched from a U.S.-made high-mobility artillery rocket system, or HIMARS, that is owned and operated by Australia. The PRSM represents a significant leap in long-range strike capability, with an unclassified range of over 300 miles and the ability to destroy moving targets on both land and sea. Army Secretary Dan Driscoll, who observed the test, called it a key step in deterring conflict, stating that the missile allows Allied forces to hold vast land and maritime regions at risk, thereby increasing deterrence. The PRSM is a core component of the Army's strategy to counter adversaries by being more agile and harder to target. Unlike older rockets, 2 PRSMs can be packed into a single HIMARS launcher, effectively doubling the long-range firepower of these highly mobile units. This successful test underscores the deepening military cooperation between Washington and Canberra under the AUKUS Security Pact, and comes amid heightened tensions in the region, particularly concerning China's posture towards Taiwan. It serves as a clear signal that the U.S. and its allies are actively working to expand their long-range precision fire capabilities to maintain stability in the Indo-Pacific.